In this lecture, we're going to begin the discussion on the mechanics of succession. The first step to determining who gets a decedent's property is to determine whether the property is probate property or non-probate property. Probate property is property that must be transferred by a probate court. At one point in time, probate was the only way to transfer property with a clear title at a person's death. So at that time, all of the deceased property was what we call probate property. And as such, it had to be administered by a probate court. But this court process became cumbersome, became expensive and time-consuming. So lawmakers developed what we now call non-probate alternatives. Non-probate alternatives. It's important to remember, however, that probate is still the default. Probate is still the default. So what is non-probate property? Non-probate property is property that passes outside of the probate process. The vehicles that are used to facilitate this type of transfer vary, but the ones we're going to focus on are inter vivos trusts, which are trusts that are made during the life of the individual, pay on death contracts, life insurance policies, and joint tenancies. Property that is held in a joint tenancy or property that is the subject of life insurance or a pay on death contract, or that are part of a trust. All these types of properties are non-probate property, so they pass directly to the person that is named in the written instrument. So, for example, if we have a piece of land, a piece of real property that is held in joint tenancy, and the instrument that creates that joint tenancy is a deed, we look to that deed to determine who gets the property at the death of the decedent. And this all occurs outside of the probate court. So if the property that we're looking to distribute does not fall within one of these categories, then it must be probated, because remember, probate is the default. So why might someone want to avoid the probate process? People want to avoid the probate process because it is expensive and time-consuming. So estate planning attorneys spend a good chunk of their time trying to characterize assets in ways that will allow them to avoid the probate process at the time of their client's death. So we said that non-probate property goes to the person that's named as the beneficiary in whatever written instrument is used. So how do we decide who gets probate property? So you might remember from one of our previous lectures that courts will try to honor the decedent's testamentary freedom. So the first thing a probate court will do is look to see if there is a valid will. If there is a valid will, and that will mentions what the decedent wants to do with that particular property, then the property will go to the person that's named in the will. So again, this is a two-step process. We look to see first, is there a valid will? If the answer is yes, we then look at the will to see if the will disposes of that property or all of the property. So does the will dispose of all of the estate property or the property at issue? If the answer is yes, then the property goes to the beneficiary that is named in the will. Well, if there is no will, or if the property at issue is not named in the will, then the property passes through intestacy. So you might be wondering what the relationship between intestacy and the probate process is. Intestacy is part of the probate process. Within the probate process, property can pass either through testacy or intestacy. If we say that the decedent or the property is testate, that means there is a valid will that governs the property, and so we look to the terms of the will to decide who gets what. If the decedent does not have a will, or the will does not cover all of the property, and we're looking to see what to do with the property that is not covered in the will, then we apply the intestate rules. Intestate rules are just the default rules that are used in the state to determine who gets the decedent's property when there is not a will. So again, intestacy rules are just the rules in the state that determines who gets the property of a decedent if the decedent did not leave a will. Let me give you an example. Samara decides that she wants her brother Jamie to have her car if she were to die. So one day when it's on her mind, Samara grabs a pen and a paper and jots down the following. I, Samara Jones, would like my brother Jamie Jones to have my car when I die. She signs this document and dates it. We'll call this document Note. This note is a valid will, and we'll talk about why that is in another lesson. But that will also mentions the car explicitly. So when Samara dies, the car is going to be probate property, right? It's probate property because there is a will and the will mentions, right? So when Samara dies, Jamie here can take the will to probate court, and the court will transfer title to the car to Jamie, because those were the wishes of Samara that were spelled out in her will. So let's say now that Samara also owned a house, but Samara's will didn't say anything about this house. Is that house still probate property? This is a bit of a trick question here. It is probate property. Why is it probate property? Well, it's not non-probate property, so the default says that it's probate property. So it is probate property. But what rules apply to it? How do we determine who it goes to? Well, the house is going to pass through intestacy, and we're going to apply the intestacy rules to it. And the reason is because the will did not mention the house. The will didn't dispose of the house. So the court applies the default rules, the intestate rules, to determine who gets the house. Now we're going to determine what these default rules are a little bit later in another video. As you may have noticed by now, wills and trusts uses a lot of specialized terminology. It helps make the concepts easier to understand if you take some time now to review the different terms that we use. They're mentioned in pages 41 to 44 of your textbook. I suggest making flashcards if you need to. Trust me when I say that taking the time to learn these terms now will help pay off dividends in the future. So far in discussing the probate process, we have talked about how the court decides who gets what. Your textbook goes into detail over what the actual probate process looks like, including what it looks like or means to open up a probate case. I think that overview is important. But for our exam purposes, the only thing you need to focus on or remember in regards to the procedures or the process that is probate is how an individual determines which court has jurisdiction over the probate. So here, there are two primary rules. The first is the county that the decedent was domiciled in at the time of death is the county that has the primary jurisdiction, particularly as it relates to personal property. But if the decedent owns real property, it is the county in which the real property is located that has primary jurisdiction over the real property. So you might be wondering what happens if a decedent lives in a county at the time of their death and owns real property in another county. Or what happens if the decedent owns multiple pieces of property with real property located in different counties. If that's the case, then the county where the real property is located will have ancillary jurisdiction over the real property. If the real property is located in a county that is different than the county that the decedent was domiciled in at death, then there will likely be ancillary jurisdiction. Ancillary jurisdiction is a probate proceeding that is opened for the purpose of transferring real property. And it is done specifically when that real property, like I said, is in a different county from the county that the descendant was domiciled in at death. So why do we need ancillary jurisdiction? Why couldn't the real property just be probated in the county that the decedent lived in? Might seem like it's just additional burden and expense, and perhaps it is. But ancillary jurisdiction serves two important purposes. The first is that it allows local creditors to be properly noticed so that if there are claims against the property, they can come forward at that time. And if not, then title is cleared. The second purpose is that it ensures that proper recording of the transfer takes place and that recording is done in the county recorder's office in which the property is located. You might remember back to property law and think about how important it was to properly record and what that meant for the chain of title. And so those influences play a part in why we have ancillary jurisdiction. Overall, the probate process is an important process that makes sure that the decedent's wishes are carried out and that the decedent's property goes to the right person. It also gives creditors the opportunity to make claims against the property and to settle any debts. So that when the property is transferred at probate, that property comes out with a clear title, meaning there aren't any liens against it. And that is it for the probate process.